morning to you all.
Good morning.
Mr. Siminya.
Good morning, Chair and Commissioners. Today we're receiving the evidence of Minister Kubai, led by Ms. Moroka.
Thank you. Ms. Moroka, you confirm that?
Confirm that, Chair. Excuse me.
Thank you. Good morning, Minister.
Good morning.
Yes.
Chairperson.
Welcome to the Commission.
Thank you.
Are you going to give your evidence under oath or affirmation?
Under oath.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. Ms. Moroka.
Thank you, Chair, and good morning, Minister. There are a number of bundles before you there, but I want to refer you to the affidavit bundle and refer you to the first document, which is your first affidavit. And refer you to the last page of that document. Is that your signature?
Correct.
And you confirm that this document is your affidavit and you confirm the contents thereof.
I confirm.
Can I then move on to paragraph 1 of that affidavit, where you tell the Commission that you are the present incumbent, the Minister of Justice and Constitutional Development, and you are appointed on the 3rd of December 2024.
Correct. I am.
Can you, before, it is not in your affidavit, but can you tell us your educational qualifications and where you were before you landed in this position?
Thank you very much, Advocate Moroka. I'm a minister currently of Justice and Constitutional Development. I was appointed on the 31st of March 2017 as Minister of Energy. From there, I moved to become Minister of Communication, and then became Minister of Science and Technology, Minister of Tourism. I acted for about 3 months as Minister of Health during the height of the pandemic, COVID-19. And then I moved to become Minister of Human Settlements, and then now Minister of Justice and Constitutional Development. I've been a Member of Parliament since 2009, which counts for 17 years as a National Assembly member. Prior to that, I was a councillor in the city of Johannesburg, PR councillor, for 3 years. So I've been a public representative for 20 years in full, and almost 10 years. By March next year, I'll be 10 years as a member of the executive, meaning member of cabinet. I matriculated from a school called Tusas Chaba in an area called Puorki, south of Johannesburg. I then went to pursue my junior degree, BA degree, at Vista University, today is called UJ. I further did a postgraduate diploma in project management at Damelin, and then furthered my studies to obtain master's degree at Wits in terms of governance and public administration, and further did a leadership development program, which is also equivalent to a master's with Harvard Business School. I'm currently a PhD candidate with University of Johannesburg. I'm hoping to conclude it in this current academic year.
At paragraph 3, you state, and if I may read it, I am cited as a third respondent in the main application brought before the High Court under case number, whatever number, which forms the genesis of this commission. In my official capacity as the minister responsible for the DOJ and CD, and as the cabinet minister responsible for the National Prosecuting Authority in terms of section 179 of the Constitution. We're going to speak later about the said quoted section. You confirm in paragraph 4 that this affidavit is within your personal knowledge unless otherwise indicated.
Correct.
If I may, unless you're reading, I know we like each other, but you have to address yourself to the commission.
My apologies, commissioners.
Paragraph 5, we talk about Proclamation 264 of 2025 and what that proclamation provides for. Do you want to tell the commission how you're involved or you were involved in this exercise, the process of establishing the commission?
In terms of the legislative requirements and the role of the Minister of Justice and Constitutional Development, when the President decides to establish a commission, the responsibility is upon the Minister of Justice and Constitutional Development to ensure that the commission is established. This includes administrative processes, legislative requirements met, ensuring that the regulations are done and are recommended for President to sign. Terms of reference are submitted to the President to authorize. Staff appointment are done. In terms of the law currently, Public Service Administration Act, Public Service Act, because the commissions, as we establish them, either you do secondment of staff or you appoint additional to the establishment. The minister therefore becomes the signing authority, finally, to ensure that the commissions is capacitated to fulfill its responsibility. The minister then gives instructions to the state attorneys to ensure that the requirements of the chair in terms of the lead evidence leaders, including other requirements in terms of what state attorney is required to do, those are done as well, including ensuring that the commission starts in terms of the requirements of what the president has said, and consistently the minister liaises with the chairperson to ensure that all the requirements of the chairperson to ensure effective running of the commission are met. And that's why I would understand the terms of reference, the establishment, the regulations, because even the proclamations are signed by the minister to ensure that they are gazetted.
Would I be correct, you also provide functional and financial support?
Yes, correctly so. That's why I explained about the administrative processes, all the requirements, ensuring that even including that the minister has the responsibility through the department to ensure that the National Treasury avails resources that are needed for the commission to run. If that does not happen, the minister has to ensure that the department actually reprioritizes, because it's not an option for the department not to fund a commission, but to reprioritize within its budget, as it would have happened with this commission, that Treasury didn't provide all the necessary required financial support, but the department had to reprioritize its programs to ensure that we meet the needs of the commissions.
Can I then move us to paragraph 6 of your affidavit?
Correct.
You talk about receiving a letter from the chief evidence leader, Mr. Semenya. Do you want to read that paragraph into the record?
Yes, commissioners, I received an undated letter late last year from the commission's chief evidence leader, Advocate Semenya, who requested that I provide in affidavit form my own account on any discussions, decisions, or considerations during my tenure that may bear on the matters set out in paragraph 1.1 of the terms of reference of the commission.
So you have been brought to this commission in terms, your response by being here is a response to this letter.
Correct.
Paragraph 7 talks about paragraph 1.1 of the terms of reference. What did you understand by this request which made reference to paragraph 1.1?
In terms of paragraph 1.1 of the terms of reference of the commission must, in relation to the period since 2003, inquire into, make findings, report on, and make recommendations concerning, I quote, whether, why, and to what extent, and by whom, efforts or attempts were made to influence or pressure members of the South African Police Services or National Prosecuting Authority to stop investigating or prosecuting TRC cases, unquote.
And you explain at paragraph 8 that this affidavit was provided in compliance with that request.
Correct. The first affidavit was provided in compliance with the request in terms of the letter.
If we move to paragraph 9, would you please read to the commission that paragraph?
Yes, Commissioner. Save for discussions and instructions given to my counsel and the legal team representing me before the Commission. In my capacity as Minister of Justice and Constitutional Development, I have not had discussions, nor have there been discussions or considerations regarding whether, why, and to what extent and by whom efforts or attempts were made to influence or pressure members of the South African Police Service or the NPA to stop investigating or prosecuting TRC cases.
Do you want to elaborate at all on this paragraph?
Yes, commissioners, and I just need to apologize to commissioners. If you hear me, my voice, I'm recovering from flu, so pardon me in the process. Since I've been a member of cabinet, as I said, from the 31st of March 2017, outside the JCPS cluster, because I became member of the JCPS cluster from the 3rd of December when I moved to this portfolio. All these years I've been in cabinet, I've not been a member of the JCPS cluster. But as a cabinet member, I've not been in a meeting where it discusses to stop any prosecution. I've not been in any meeting where it gives instructions or even the cabinet resolution. Such does not exist since I've been a member of cabinet, nor have I been called to any meeting outside cabinet to go and discuss or even be informed or even see a document that speaks to stopping any prosecution on TRC cases.
You've already talked about the support that you have given to the establishment of the commission, so we will jump paragraph 10 and move to paragraph 11, MTK1, that you have attached to your affidavit, which talks to a progress report as at 13 February 2026. And this one, it is at page 8 of the bundle. Do you want to summarize what you want to say about, and Chair, we have updated the progress report. We have filed it today with the commission.
Yes.
Do you want to, in very summary form, talk to MTK1, which has been updated to today?
Correct, SC. Commissioners, my responsibility as Minister of Justice and Constitutional Development is also to oversee the work of implementation of the TRC recommendation. This is inclusive of the prosecution, but not limited to the prosecution. So our work goes from the point where I had to start as I arrived in the portfolio to ask in terms of update where we are. And today we have an update of the work that we have been doing. I can account as the minister in terms of this area of work, that in terms of the once-off reparations has been done, and we recently issued a communique because when I arrived in the portfolio, I found that there were about 4,000 people that had not received their reparation, which was once-off. We had to go and publish that in the newspapers so that those names who appear and calling for them to come forth so that they can benefit. In terms of the basic education and higher education or general education, we continue to provide support to those families as per required, and this is expected to almost come to an end around 2037 in terms of our projections, in terms of those that we are providing support and the financial resources. Again, commissioners, I can indicate one of the areas, having my experience as Minister of Human Settlements, we did find that in this area of work in terms of housing reparation, work was not in a level where it was advanced. We moved to conclude the issues around that work, and we actually launched the project with the President at the beginning of this year. And I can confirm that that work is going ahead, where we are providing reparation for those whose houses were bombed during apartheid time or they were destroyed because of wars civil wars within the communities. For example, if we look at what happened in Ndwedwe, where there was a fight between, and a community was wiped out, and everybody, women and children, were displaced in that community when their houses were burned. We have been able to go back and provide that. We have concluded the Gallows Project. The Gallows Project is what we have seen that apartheid government actually killed a number of our activists, hanged them without any justification, we can say. And therefore, if we look at that Gallows Project, it was initiated to be able to give the remains to the families, especially in African culture. We are not able to have a closure as family when the remains of our loved one have not been where they are supposed to be with their ancestors. This was one of the projects which was quite touching and significant for us as the department. I can confirm, Commissioner, that this project actually came to an end. We ensured that we fast-tracked it and handed over all the remains that were under the Gallows Project. Reburials have been done and the remains were handed over to their families and reburied. So it's work that we continue to do. The medical benefit is one outstanding. This year, we are concluding the issue of the community schemes, which we are doing 18 projects that we have been requested to do in terms of ensuring that the legacy of apartheid is known in our country. Generations that are coming are able to remember that the atrocities that were perpetuated by apartheid government can never happen again in our communities. And those memorial sites will be done continuing by us. We have identified 18 sites that Cabinet has been approving, and we're working with communities to be able to do that. So we can confirm, commissioners, that this work has not been just a one-day work. It's processes, but it involves the victims, it involves communities, for us to be able to account to our people in terms of this work, but more proudly to say, in many areas actually we've been able to ensure that the reparations happen and we are able to see closure and help families find closure in terms of the pain that they've experienced under apartheid government.
Minister, respectfully, may I make a suggestion that you address yourself to the commissioners and in particular to the chair?
My apologies for that. I think it's easier when I read to look ahead. So my apologies for that.
I understand.
I'll have to adjust my chair. My apologies for that. I'll adjust to look this way.
Can we talk more briefly about the President's Fund? There has been suggestions that it has accumulated a lot of money. We accept that there's been interest that has accrued. Are you able to talk to the Commission about the President's Fund and the amounts there and what disbursements are being envisaged in respect thereof?
Definitely, I'm able to do that, Commissioners. Final reparations in terms of the allocations until 30th of June 2026, it's 126 million. We're looking at education assistant, meaning basic and higher education. It's sitting at 600 million in terms of the work that we have done. If we look at that updated document. Exhumations and reburials, we're sitting at 21. Housing assistance, I must say on the housing assistant, commissioners, this was our estimate. Current figures do show that we are likely going to go higher in terms of the amounts of what we have to do. But we have estimation of 722 million in that. Medical benefits, that has not been utilized currently, is sitting at 214 million. And then community rehabilitation that we are implementing this year is sitting at 500. So that's actually what we are able to articulate to. Just to indicate, because sometimes what we find is that we can account that in terms of the many money that we've been able to accumulate has been on interest that we are able to augment, especially on the areas of the housing reparation that is able to go. Because somebody can ask, how are you going to close that gap of the housing reparation that has gone up? We will be able to utilize the interests that have been there to be able to support us. But in terms of projections, all the money will be utilized by 2037 latest in terms of the projects and the projections and the commitment to the families and the individuals that we are supporting. Thank you.
And this would have been at page 13 of the update.
Pardon, I missed that.
We were looking at page 13 of the handed up update.
Correct, SC.
Thank you. Can you then move to paragraph 12 of your affidavit? You talk about inquests and you talk about those that are on the roll and those that are on the criminal court roll. Do you want to read paragraph 12?
Correct, Commissioners. This is MTK2 SC, am I
Yes,
correct?
it is. Yes, it is.
Okay. And can I just give a bit of an explanation on this one, Commissioners? So in terms of when I arrived in the department, so when you arrived, I was appointed December, and unfortunately, because my mother passed away in December, I took leave for that month, the remainder of the month. Then I started in January. And between January and March, I had briefings from the department in various areas because I'm responsible for two departments. So it's the Department of Justice and Constitutional Development and the Department of the Office of the Chief Justice. So I received briefings across on all those areas in terms of those 3 months, but also in the process ensuring that we have plans in place as per our annual performance plan. Now, part of the report I received was on the TRC. Now, on the TRC, because, and I want to explain this page, you'd see there's a list of inquests starting from the one on Mr. Ahmad Timon in terms of the process, until as you go in terms of all those ones, it gives you to the next page where it goes to say, these are the cases, matters, request held or inquest reopened, yes or no. It tells you all the list of them that have been opened, which are 12 that I'm accounting for. And then current matters on inquest roll that are still to be, they've been reopened, they're currently processing. And then convictions that we've been able to see in that page, which are 3. The Wesley versus the S versus Wesley Matonsela, the S versus Maris, the S versus Engelbrecht 2, and then the matters on the criminal court roll. What I want to explain, Commissioner, is that when I got appointed, one of the issues I asked the people there to say, how does this work? Because it was not familiar for me. And the team took efforts to explain how the process works. Because I wanted to understand at what point do we register for the inquest, at what point do we have it on the roll, at what point do we see closure, and which one falls in which direction, whether going for criminal procedure and all that. So the team explained that when a matter is brought to them or the list, they take the list, they look at it, they assign an investigator. When they assign an investigator should be able to look at the issue, whether this issue can be investigated properly, can gather evidence that will stand the scrutiny of a court. Once they have preliminary work, then they put it together to have an inquest, an investigation, then they do an inquest. And they explain that part of the process is that in some of the areas is that you've got to reconstruct the scene. Reconstructing the scene to be able to have what could have necessarily happened. And they said some of the times this becomes difficult. This is what they explained to me. It becomes difficult because you find it's a building that they say somebody was thrown out of the window. When you go to the building, you find that the building has been renovated and converted differently. The window doesn't happen to be there anymore. So this is what they were explaining to me. And the difficulty sometimes even to get cooperation with people who must provide evidence. You would note, Commissioners, that during this time as well, where I am on the portfolio, for example, some financial support was not provided to the families who are going to hear the matters that relates to their family members. Secondly, those who were accused were not provided support in terms of legal representatives so that they can appear. So this was also one of the issues which was a hurdle. You would note that then we changed the policy in terms of Legal Aid South Africa to have an extended mandate to this. We also changed the responsibility to be able to transport the families, to be able to attend the inquest so that they can be able to be part of the proceedings in terms of the work. So I thought just not only giving this list, but to explain what has been given to me as an explanation on how the processes works and why some of the things will move quicker, others will move slower. Thank you, Commissioners.
And if we were talking about MTK2, but MTK2 has also been updated at page 47 of the bundle. Is that correct?
Correct, correct, Commissioners.
Can you then read paragraph 13 into the record?
Save as aforesaid, I do not have other information concerning decisions, discussions, or policies affecting the investigation and prosecution of TRC cases or any material relevant to the inquiry arising during my tenure in my position.
Thank you. We then move to a different topic. The department was asked for documents and documentation, and you respond to that at paragraph 14. I'm not going to ask you to read that paragraph, but refer you to paragraph 17. If you could please read that paragraph.
Nevertheless, the Ministry and the Department of Justice and Constitutional Development are committed to cooperating with the Commission. To this end, the Department of Justice and Constitutional Development is currently attending to the Commission's information request and will be liaising with the Commission to facilitate access to the relevant records within its position.
And as far as you are concerned, you do know that your acting DG has compiled a set of documentation to the Commission. Is that correct?
Correct.
Can I then ask you to read the concluding paragraph of your affidavit?
Save as stated in this affidavit, no documents or information which have a bearing on paragraph 1.1 in the Commission's terms of reference are in my possession.
Possession. Thank you. Can we now move to your supplementary affidavit?
Yes.
Can I again refer you to the last page of that affidavit?
Mine is second last page, SC. Last page is the Commissioner, if I'm correct.
Thank you.
My
Thank you for
signature
the
is on
correction.
37.
And that's your signature at page 37.
Correct.
And you confirm the contents of this supplementary affidavit.
Correct.
You again state that you are the minister, you haven't been relieved of your duties.
I'm
to
still the
date.
Minister of Justice and Constitutional Development in the Republic of South Africa.
From page 3 to paragraph 3 to paragraph 5, I beg your pardon, to paragraph 4, the affidavit talks to the difficulties about submitting a supplementary affidavit because you were being referred to or requested to furnish more information and you didn't understand. If I'm correct, correct me because I'm asking you a leading question. To understand what it is that the Commission wanted from you.
Correct, Commissioners. My difficulty was I wasn't sure whether I'm asked in my capacity as the current minister or should I respond for all the other ministers. And when I looked and interacted, because if you are to respond on behalf of others, then you'd have to have consent of them. And when I checked, they had indicated that they actually are appearing before the Commission. So fortunate for me, all my predecessors are actually lined up to either others have testified, others will be testifying. So it was a bit difficult whether I account for myself from December until now, or do I include any other matters? And that's why I had requested senior counsel together with the legal team to request for clarification on these matters. And that's what would have informed the initial affidavit in terms of what would have submitted.
And then if I refer you to paragraph 8 of this supplementary affidavit. If you could please read it into the record.
On or about 17 June 2026, the Commission Secretariat circulated a proposed timetable which reflected that the Commission intended to call me to give evidence before the Commission on the 28th July 2026.
Paragraph 9.
In addition, counsel representing me at the Commission was advised by the Commission's evidence leaders that my previous affidavit was inadequate. It was, however, not apparent what more was required from me or why my affidavit was considered by the evidence leaders to be inadequate.
Can I then confirm that we received, or you received a letter wherein the evidence leaders then sought from you what it is that they sought, an understanding of your understanding of Section 179. Am I correct?
Correct, SC.
And that in the first letter by Mr. Siminya, there was no reference to this inquiry.
Correct, SC. I have attached all the letters.
But at paragraph 12, you indicate that this supplementary affidavit is accordingly in response to the above-mentioned indication from the Commission's Secretariat, reflecting the further evidence that the Commission would like to have from you.
Correct. Would you like me to read it to record, or it's fine?
It's not necessary. But what is necessary is to read paragraph 13 and your comments there too at paragraph 14.
Before dealing with the evidence that the Commission would like to have from me, I refer to paragraph 2 in the Commission's letter, which states, I quote, "The Commission has had evidence that the performance of the National Prosecuting Authority and the South African Police Service institutions in the discharge of the recommendations of the TRC have been dismal, in particular because they did not follow the recommendations of the TRC. That is, those who were refused amnesty and those who did not apply for amnesty were to be prosecuted where evidence existed," unquote.
At paragraph 14, you note that has been stated in the above-mentioned paragraph, but you want to explain what your understanding of what paragraph 13 seems to indicate.
Yes, I note that what has been stated in the above-mentioned paragraph, given that the Commission of Inquiry is still underway, any determination will be made by the commissioners having regard to all the evidence placed before them. And I must say, commissioners, in my responsibility as the Minister of Justice and Constitutional Development, part of the duties in law I have and administratively is to advise the President. So it will be difficult for me to have an opinion when there isn't an evidence, but also when the President has established a commission to have an opinion on the matter, while I am referred as an advisor of the President on the matter where we are seeking evidence, we are seeking information, and the commission was established particularly to be able to assist government in this regard. Thank you.
We now then move to the inquiry that was sought from you about the provisions of Section 179. We will not read the law, but what we will deal with is your understanding of your responsibilities in respect of the Constitution, 1796. They've given you a bundle there about the section, which deals with the Constitution and the fact that the head of, 179 talks to the National Director of Public Prosecutions, 1792 talks to the powers of that institution, and these are enumerated in paragraphs 15, 16, and 17. What is your understanding of these provisions?
Would you want me to first read, I don't know if commissioners, you want me to read that into record?
No.
Or you just want me to explain it?
If I could ask, all of us know what those provisions are. If you could understand,
Yes.
give us your understanding.
Yes, we are familiar with the provisions.
We should hope so, Chair.
Yes.
Thank you.
Okay. No, just The issue for me here is that, for example, I think in paragraph 18, I deal with the fact that I have found the police already in place. Now, the responsibility of the Minister of Justice and Constitutional Development, or the minister responsible for justice as is put in the Constitution, is that you do not interfere with the work that is being done by NPA, especially on prosecution. So NPA is independent. They must deal with the issues of their own work in terms of prosecution without the interference of the minister. Section 33 of the NPA Act stipulates how the minister can request a report from NDPP, National Director of Public Prosecution, if they are concerned, but there must be a trigger for it. So you don't wake up every day as a minister and ask for report in terms of case section, case what, and you want to know. That would be deemed as interference. And I'll make this example just to elaborate. When there was a public outcry in relation to the case of Omotoso versus of the rape of many young women in the Eastern Cape, there was an outcry because the presiding officer actually did reflect on the conduct of NPA. Out of that, I did a request in terms of Section 33 of the NPA Act to say, National Director, give me an account of what has happened. So the trigger for me was the outcome of the case, the public outcry, but the report or the reflection by the presiding officer of the conduct of NPA. Out of that, then I requested a report. So there's a context where the minister gets involved, but there's prescription in how the minister can actually do that oversight. So the oversight that is being envisaged by the Constitution doesn't mean minister then sits with the NPA and NDPP every day to ask for cases, to ask how this case is doing. If you do that as the minister, that will be deemed as interference. There must be a trigger that says, why would you want this report when you ask it under Section 33? So the oversight is around performance, which I do quarterly. You look at the performance to say, these are the prosecution, this is the targets that you have set. How far have you gone? Have you met the targets? Have you not met the targets? What are the issues? Have we been able to appoint the people? If there are investigations or complaints against individuals within the NPA, and then the minister then can be able to request a process to be done. If it's the people who are appointed through what we call presidential appointments, then an inquiry needs to be done. The minister then will have to recommend to the president to do an inquiry. So the law is very specific in the role of the Minister of Justice in terms of overseeing what needs to be done and how the barriers must be. And I do believe, and I hold that belief, that that should be respected and that should be protected at all times.
Having said that, Minister, can I ask you to read Section 32 of... I will read Section 32 to you because then looking for it is going to be difficult. It is Section 32, Commissioners of the NPA Act. And Section 32, 1B says, subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out or performance of his or her powers, duties, and functions. And the provision talks to improper interference. So you've spoken to that, correct?
Yes, correct.
Thank you. If then, can I then move us to paragraph 26 of your affidavit? And you've explained it, but if you could read paragraph 26 of the affidavit.
I may request the information and reports in terms of sections 33 2A to E to enable me to fulfill my mandate of exercising final responsibility over the NPA. I do not get involved in the day-to-day operations of the NPA. The information and reports that I receive do not give me the authority to direct prosecutorial decisions, nor do I have the power to do so.
You talked about the fact that in January 2025 to March 2025, you received reports from different organs that reported to you, different organizations within the department that reported to you. And you
Correct.
then make specific reference to that at paragraph 27.
Correct.
And-
In respect to the prosecution of TRC cases, I received a report on the progress on matters emanating from the TRC from the previous NDPP advocate Shamila Batoi on 3 March 2025. This report provided me with the status of the TRC matters dealt with by the NPA in collaboration with the Directorate for Priority Crime Investigations. A copy of the report is attached as Annexure SA6.
And what did you do with this report?
In the report, when I received it, actually it was giving quite a lot of positive reports of progress that I believed that were not in the public domain. And in my comments, for example, in one of the submissions that I received, I actually urged the department to actually communicate publicly, because even myself, I had limited knowledge of the work that has been done by the department and NPA in this regard, because popularly in the public domain was that nothing was being done.
Would I be correct to say that by the time this memo comes to you, the High Court application by the Galata Group has been issued?
Correct.
And that therefore the comments by Mr. Nell are in relation to that matter?
Correct.
And this is a leading question, it can be objected to, but the fact of the matter is that the discussion between yourselves in the department and Mr. Nell was in regard to that litigation, and you're entitled to refuse to comment on that comment.
I think it's an internal process. I think by privilege of the document being here, commissioners and team have that privilege to see what we would have communicated. But it helps us when we track issues, when we make those comments, so that we are able to follow up in the instructions we give toward our officials.
Can we then move to paragraph 28?
Yes.
Paragraph 28 talks to section 38(1) of the NPA Act. Do you want to read it into the record and then give a very short explanation of what you wanted to tell the Commission about in respect of this section?
Section 38(1) of the NPA Act provides that the NDPP may, in consultation with the minister and the deputy national director, or a director may, in consultation with the minister and the national director on behalf of the state, engage persons to perform services in specific cases, which services include the conducting of prosecution. When I arrived in the portfolio, there was quite a lot, but it was a broad issue within the NPA, how NPA was contracting Section 38. At that time, there was no policy. So it was also in the public domain. It's one of the first things that I had to deal with, where an individual was saying that minister does not want to appoint them, which meant my predecessor. So when I looked at the matter, I asked, what is the problem? We found that there was differences between the department and NPA in terms of the amount to be paid. Compared to what we have as a policy in the state attorneys, NPA wanted to pay higher amounts. What I then did, I said, because we are subjecting the processes to individuals, let's rather have a policy in place that sets also the parameters of payments, the nature of skills that would be required, because these are additional to what we have. So there has to be justification why we actually contract a Section 38. It can't just be on cases that we have capacity to do as NPA, then you go and want to contract. So out of this process then, there was a request that we do the policy, and out of those then we did. And in relation to the TRC recently, we have appointed under Section 38 to assist in terms of a person who can be fully available to to do the case. Why we had to appoint, because the case was going to run parallel concurrently, and at that time, we realized that if we take one of the advocates or we take one of the prosecutors, the likelihood is that they will have to postpone the matter, and therefore to have somebody who's contracted full-time onto the case and give themselves time, then it allows us to have that TRC matter to be heard and concluded in time. So that's how we would have been able to contract in this regard, and what that paragraph saves to help the commission in that regard. Thank you.
Thank you. So we will not go into paragraph 29 and 30 because we've already explained that.
Yes.
Can we talk to the independence of the NPA, which you then discuss under paragraph 33, 34? Yes, 33 and 34. Maybe read it, it will make our lives easier.
Okay. I stress that the NPA is an independent authority which must, in terms of section 179(4) of the Constitution, exercise its functions without fear, favor, or prejudice. Section 179(4) of the Constitution safeguards the NPA's prosecutorial independence, and this is reinforced by section 32 of the NPA Act. To further safeguard its independence, in terms of section 35(1) of NPA Act, the NPA is accountable to Parliament in respect of its powers, functions, and duties, which will include decisions regarding the institutions of prosecution. To this end, I provide briefings to Parliament from time to time, as and when required, regarding the work of the NPA, including respect of the TRC cases. By way of the example, please see my response to the questions in the National Council of Provinces on 17 June 2025 regarding the NPA's role in the reopened inquest and apartheid era accountability, which is attached as Annexure SA8. Parliament is therefore able to hold the NPA accountable for its decision. It does not give Parliament the power to direct prosecutorial decisions, nor does Parliament do so. Prosecutorial decisions remain the sole discretion of the NDPP. If I may explain further, Commissioners, with your indulgence. So we have what we call the annual performance plan of the department. One of the sections does include the targets of NPA. Annually, then, the minister accounts quarterly, and then at the end of the year, it's an annual performance report that is tabled before Parliament. It includes everything that is within the Department of Justice. But with regards to NPA, on prosecutorial matters, the NDPP annually is obligated to submit an annual report directly to Parliament. And the NDPP has to go before the Portfolio Committee of Justice and Constitutional Development to present that report. So I am cited. I don't input into that report. I can ask questions when I receive the report, but it's not to me, it's not tabled to me, and it's not tabled through me. It's tabled directly by the National Director of Public Prosecution, and the National Director of Public Prosecution leads a delegation to explain to Parliament in terms of their responsibility and their role in terms of prosecution. So I thought, let me explain, even in terms of accountability, that is precise, and even how Parliament's oversight has been established to assist in terms of ensuring there is no conflation of roles between the Minister of Justice in what she's expected or he is expected to do, and the National Director of Public Prosecution's accountability to Parliament.
And SA8 is an example that is given at page 88 and is titled Minister of Justice and Constitutional Development. Mamoloko Kubai replies to questions in the National Council of Provinces, but it was in specific reference to your accounting on the NPA to Parliament.
Yes, Commissioners, these are questions to Parliament. So question sessions in terms of the rules of Parliament are directed to members of the executive, no one else. So this would be my answering to Parliament in terms of the work of the portfolio.
Thank you. Can I ask you then to read your concluding paragraphs that is of the affidavit, and not the concluding questions that I'm asking you, but concluding paragraphs, and that is paragraphs 35 and 36.
I have never made any effort nor attempted to stop the investigations or prosecution of TRC cases. I respect the NPA's independence while I fulfill my oversight role as Minister of Justice and Constitutional Development in terms of Section 179(6) of the Constitution.
Thank you. Those are your two affidavits, correct?
Correct, Commissioners.
In the first affidavit, we referenced the fact that you asked the ministry to help collate documents, and the documents were sent to the commission, which then disseminated the questions to everybody else.
Correct.
At my count, it was 443 pages of documents. Mr. Vani says it's even more, it's 600 and something.
Correct.
Can I refer you to a new bundle that has been given to you? And it's referenced as Talata bundle to cross-examine Ms. Kubai.
Yes, I'm there, Commissioners.
My first question to you is, you do know about the Rodriguez case? You haven't read it, but you know of it.
I know of it.
Have you read it?
I didn't have to. I didn't.
Okay. And the case was before your tenure, is that correct?
Correct. Actually, I was laughing when I looked at it. I said, at that time, my attention would not be anywhere else because I was holding two portfolios at the same time. I was Minister of Tourism, and I was Minister of Health. And at that time, tourism was being disseminated by COVID-19, and at the same time, I had to fast-track the rollout of the vaccine. So my attention would never have been anywhere else except on those two critical matters that I was faced with as a minister, having to ensure that the country is safe as acting Minister of Health, but also having to ensure that I protect the sector that was being shut down by COVID-19.
Well, the representatives of the Kalata group contend that the ministry's stance has changed from, and I quote, I think if I'm quoting correctly from them, from political constraints having some impact to that the delays in the TRC cases were not due to any outside pressure or steps, but are attributable exclusively to individuals within the NPA and SUPS who failed or declined to pursue the cases. And then the comment is that, or the contention is that the approach from the ministry appears to have changed since your appointment, to the extent that there was a time when there was a concession that this was a correct statement, to the contention now that this is not a correct statement.
Commissioners, I'm not aware of a change of a position, and I wouldn't have been part of any of the previous positions. And my involvement relates to what I have before me and what I have received as information. And where I'm sitting, I don't think such is correct. I'm not aware of.
Was there at any time a briefing that told you that this was the department's position on this issue?
Not at all. As I explained earlier, how the briefing happened and what I was briefed upon in terms of all the other areas, the construction of scene, and for me, it made logical sense when it was explained. I have not been briefed that there was a position that there is a political interference. None of the officials actually came to me to brief me as such. And I do not have a submission that was made to me as a minister that gives such.
What is your view on this conclusion, given the fact that you have said that the commission is entrusted with discovering what happened or what did not happen?
I think it will be dangerous for me to give an opinion without facts, because the commission is set up precisely to be able to determine by who, when, and how the interference happened. Whereas as the Minister of Justice and Constitutional Development, I think it will be a very, very dangerous thing if I can do that, Commissioners.
I then refer you to a memorandum which is cited. No, I want the reference. It's at page 404 of the new bundle. It's a memo from Advocate Patoi to 391 of the new bundle. 391. Are you there?
Yes, I am.
Do you know of this? Maybe if I can preface this by saying it's one of the documents that we submitted, that you submitted as the ministry to the commission.
Correct. We were requested to submit documents, so we asked both the department, NPA, to give us all the documents and anything that is related to TRC. So this is one of the documents that was submitted for us to process through.
But you have never seen this document?
No, I have not seen it before when we compiled this affidavits.
Can I take you to page 404?
Ms. Moroka, I'm not with you. I'm not on the same page with you.
My apologies, Chair.
I don't have, they missed the speeches. Thank you. You may proceed.
Do you see the date that Advocate Patoi signed the document? It says 2020, the 2nd of December.
Correct, I do see it on page 404.
And it's a memo purportedly addressed to Minister Lamola, who was then the Minister of Justice.
Correct.
And do you see that under Ms. Calais, the document is unsigned?
I do see commissioners and also even the deputy minister and the minister not signed.
What do you make of that?
In my experience as minister, and if I may, when a submission is made, a submission comes from the author of the submission, who then transmits it through. Now, the Director General needs to sign the memo, because in terms of the processes, the Director General is the advisor of the minister in how we would see things. So the Director General has a responsibility to look at the memos that comes to the minister, to be able to advise the minister, one, in terms of compliance of issues in law, but also if what is being recommended, minister can consider. What I find difficulty with the memo is that neither has the Director General signed the memo, neither has the Deputy Minister signed the memo, neither has the Minister signed the memo. Now, the only signature we have is the signature of Advocate Patoi. No signature of either of the colleagues that have been. And this can only mean one thing for me, and I don't want to be making assumptions, but because Minister Lamola will be appearing, perhaps he'll be better placed in making sure, because any recommendation, you do make sure that the minister sign. Because in that signature of the minister, in a memo, it tells you the feedback of the memo. For example, with how I do things is that in all the memos you'll find, even when I sign, if the entirety of the memo, you find that I agree with the memo, but there's a particular paragraph that I will have a problem with. And then I would be able to write in notes to say, this memo, I agree with the thrust of it, but the particular paragraph I have a problem with. Now, sitting with a memo with no comments from the Director General in the department, the Deputy Minister, and the Minister makes it difficult to understand whether actually the memo was processed. Because the memo could have started and ended there, and you might find that neither of them have had sight of it because their signatures are not attached. We try to see if there is any other memo, because in the process that we do things, and in my years of experience, minister signs, so in the ministry, there will be registry. The ministry will sign and keep a copy and send back to the people who have signed. For example, if I receive a memo today from NPA, it will be processed, it goes to the Director General, it goes to the Deputy Minister, and then it comes to me. And in the ministry as well, it's recorded both in the Deputy Minister's office, so it will be recorded in the DG's office as having been received, go recorded in the Deputy Minister's office as having been received, recorded in the Minister's office as having been received. And then a copy that is signed with the comments whether approved or not approved, because still the minister has to approve or not approve. So a memo, it can be at the level of a minister. If it's for noting, it's for information purposes for the minister, then it will say for ministers noting, then it's information purposes. But if it's for approval, if we look at there, it says it is recommended that the minister takes note of the content of this memorandum and arrange a meeting so that all the relevant issues can be properly presented and debated, and a proposed plan presented to the minister. So minister needed to approve this type of a memo. He needed to say, I agree with what is in the content, but I also agree with the proposed way forward. Now, as I sit here, I do not have any of those. And in my experience, could only mean that maybe the memo never went through the process. It ended at one person and never got processed. But as I say, Chair, I understand my DG dealt with the matter, who is currently acting, which is acting DG Pile, who was before the commission last week, and therefore Minister Lamula will be in before the commission. So they would give better clarity, but I am a bit worried in the manner that we found this document to be. Thank you.
What you've just explained now is what is called the root, is it routing or root process?
Yes, it's called the root process of memos.
Thank you. Having gotten a lecture on root process of memos, Chair, that will be the evidence of
Yes,
the minister.
thank you. Yeah.
Minister, this document we've just been dealing with, which you say wasn't processed, just so I understand you correctly, this is one of the documents that your ministry provided to the evidence leaders.
Yes, correct. We, as I said, we asked both NPA and the department to find any documents that relates to any matter on TRC so that we submit. So
Okay.
if you look at the first page, that it will say our copy, meaning from NPA.
Thank you.
Thank you. Ms. Morocco, I think this would be an appropriate time, or before we adjourn, let's take clarificatory questions. Mr. Kuala,
Good morning, Chairperson. Thank you. We do not have clarification questions.
thank you. Mr. Profi,
Good morning, Chair. Equally, we have no clarification questions.
thank you. Is there anyone online?
Morning, Chair. Thank you, Ms. Mchizana. We do not have clarificatory questions.
Thank you, Ms. Mchizana. Anyone else? Yes. Mr. Van, I think before you conduct your cross-examination, this would be an appropriate time to adjourn for tea and reconvene at 11:20.
As the commission pleases.
Thank you. Thank you, Mr. Vani.
Thank you, Chairperson. Minister Kubai, thanks so much for taking time out your extremely busy schedule to be with us today. Let me first say, we do not regard you as a person of interest in these proceedings. The matters before this commission took place long before you assumed office. We also want to thank you for the support that your department has given to the commission, and we hope we can count on that support through to the end of the commission. We're also grateful for your department in finding documents, the latest batch which arrived last Friday. I assume, of course, you're not in a position to have read those documents, but can I ask whether you have received a briefing on the contents?
Commissioners, let me first assure Senior Counsel that indeed we'll continue to provide the support as required by law to the Commission and ensure that the Commission fulfills its mandate to the end. I don't think you should worry about that. I thought it's important. Second one, yes, I have received a briefing from my legal team.
Thank you, Minister. And I'm also grateful to you for elevating me to the status of senior counsel, but in fact,
my apologies.
I'm just a lowly junior. Perhaps we can start with the document that your senior counsel put to you in your evidence in chief, and that's the memorandum that's dated the 2nd of December 2020, addressed from NDPP Betoy to former Justice Minister Lamola, titled Briefing on the TRC cases. And as was pointed out to you, Commissioners, that's between pages 391 and 415 of the bundle. And it's because of the contents of that document that we just have a follow-up question. And before I put that question to you, I just want to read two short extracts. The first one is a line from paragraph 2.29 at page 399. And I'll just wait for you to get there. NDPP Petoy says the irreparable damage caused by the blocking of investigations for a period of 7 years cannot be underestimated. And then one more extract, and this is paragraph 3.1 at page 402. The consequences of the willful blocking of TRC investigations at a critical time and for a protected period must be accepted and responsibility taken. This is one of the greatest impediments to being able to do justice to the cases. Full documentary evidence proving the extent of the interferences in the NPA's possession. Should the Minister require, we stand ready to make a presentation to the Minister so that there is no misunderstanding of the issue and its consequences. Now, we hear what you say, that you've never had sight of this document previously, and you've also pointed out that the only person to sign, at least on this copy, is the NDPP herself, but neither the DG, the Deputy Minister, or the then Minister signed off on it. Can we ask whether you've instructed your department to investigate this document and to see what happened to it, given that it must have arrived at your department, since it was your department that provided it to the Commission? Can we ask whether such an investigation is going to take place, or whether you're in a position to ask for an inquiry within your department to ascertain what happened to that document?
Commissioners, firstly, my apologies, as I said, I'm recovering from flu. Firstly, as I explained the process, when you look for documents, and even when you, for example, when I'm not here, when a person goes to the department and looks for documents during my tenure, records do exist that this document has been processed. Now, with this particular memo that we have in front of us, we did not find it in any of the records of the department. We found it in the records of NPA. That's the first thing. Hence, it's written our copy, because it was NPA team that was making it available to us as we inquired of the documents. That's the first issue. Number two, when I arrived in the portfolio, Advocate Batoi was on the portfolio. In my briefing, this matter was never brought to my attention. As I say, in the briefing, I asked, why does it take, and I'll make another example. One of the issues that I had to deal with was the inquest request by SSCP in relation to the Crisani matter. And as part of trying to understand why has the matter, they would differentiate that when there's been a person sentenced, in relation to that, it can't be a new thing because somebody has taken responsibility. And part of the discussion has been with the team around the matters of inquest, around the matters of TRC prosecution. There is no memo, there is no briefing, there's not even a letter from the former NDPP to Minister Kubai in relation to the matter. Because I would understand, or my expectation is that if this was the case, when I arrived, if I was in that position where I believe something has happened, and you have a new principal, I would jump on the opportunity to brief that principal to say, hey, we've been having this problem, therefore help us to unlock it. As I say, when I looked at the number of inquest commissioners, if you look at it, I've signed off a number of inquests under my tenure. So there was no warranted questioning to say things are not moving, because things were moving. I was receiving requests for inquest. I was receiving updates of what is being investigated and how far the investigation is. And in all the cases, as you can see, quite a number of inquests started under my tenure as they started, including the CREDOC 4, as they were opened. I was there at the court in Pietermaritzburg when the inquest started. So from where I'm sitting, there was no basis for me to believe that there's something wrong. Secondly, whether I will investigate, I can't do duplicate work, because now we've taken a decision as government to set up this commission to be able to do the investigation and therefore bring everybody, including Advocate Batoi, to come and explain what did she mean by this paragraph and how she had dealt with it, what evidence was before her in making this paragraph, and the recommendations to the minister.
Thank you for that clarification, Minister. My learned friend also referred you to the Rodriguez case in relation to the stance of the ministry on the question of the undermining or interference with the TRC cases. Now, you've indicated that at the time of the Rodriguez case, you were quite busy with a range of other matters, not least dealing with the COVID health crisis. Just to give you a brief background, this was an application brought by one João Rodriguez in 2018 for a permanent stay of his prosecution in relation to the murder of Ahmed Timol back in 1971. And this arose from the reopened inquest that had taken place in 2017. So that's essentially the background. And Mr. Rodriguez's main complaint was that the long delay undermined his right to a fair trial. Now, in that matter, the NPA, and I'm not going to go into detail, but they did file affidavits in which they conceded or admitted that the interference contributed to the long delays.
if Mr. Vani is going to quote what the witnesses said, it must be very accurate. He must say what Mr. Pretorius says, not a general statement without qualifying by the evidence of Mr. Pretorius. Is it Pretorius? Before this court.
Pretorius, Advocate Pretorius.
Advocate Pretorius.
Yes, I'd be happy to do so with
Yes,
with
you
the
may
leave of the
proceed
Commission.
to do so, Mr. Vani.
So there are multiple passages from his supplementary affidavit
Just
dated
give
4
us the
February.
relevant page.
But the date is 4 February 2019 of the affidavit. I'm just going to quote one passage.
Page.
Chairperson, it's at page 88 of the bundle. What page does it start from? It's the cross-examination bundle. The affidavit itself starts at page 71. It's red paginated number 20, at least 71, and I'm just going to quote.
71 in red, and page 276, and that's McAdams' affidavit. 271 is this one.
Chair, in the bundle that I have.
Is it the, are you quoting the pages in red or black, Mr. Vani?
In red, actually.
Yes,
The number at the top in black would be
it's 281,
264.
264.
All right. The bundle that I've been given has different page numbers, but I'm just going to quote from paragraph 2.11, just the first line. And the red paginated number I have is 88. It reads, the first respondent does not deny that the executive branch of the state took what one can describe as political steps to manage the conduct of criminal investigations and possible prosecution of the perpetrators.
Are you on the same page, Minister?
I am, Commissioner.
thank you.
Thank you very much, Chairperson.
Thank you, Chairperson. I'll just read that line again.
Yes, you may start again, Mr. Vani.
As the Chairperson pleases. The first respondent does not deny that the executive branch of the state took what one can describe as political steps to manage the conduct of criminal investigations and possible prosecution of the perpetrators of the political murders such as that of Mr. Timol. There's several other quotes which I can go into, but I think that suffices.
No, it does not, Chair, if I may. Our objection, well, firstly, the minister is now being confronted with documentation that she hasn't consulted with her legal representatives about. Secondly, this is the supplementary affidavit to the High Court matter, and not what Mr. Pretorius then told this commission in response to these allegations, these assertions that he made here. So you're not giving the witness the total conspectus of Mr. Pretorius's evidence. You're picking, and that is cross-examination, because you're picking what you want to pick and asking questions. Otherwise, you're going to have to go through each and every assertion that Mr. Pretorius makes and then ask the question. Otherwise, we are objecting because she has not had the opportunity to have a look at this. You have not placed it in the document that you said you're going to ask Mr. Pretorius, Minister Kubai about. This is all new. We have gone through these documents, Chair. The minister hasn't gone through them. You then piggyback the question,
Yes.
the sections that you want to put to the minister when she hasn't got the entire record in front of her.
Mr. Vani?
Well, it's not clear to me what the objection is, because I'm simply putting to the minister the stance of the NPA in the Rodriguez matter, nothing further than that. There's no need for me to go into the whole conspectus of what Mr. Pretorius has said before this commission. the only relevance for the moment is what the NPA's stance was.
Yes, I
In the
will allow
Rodriguez
the
matter.
question, Ms. Moroka. Yes.
Your mics.
Number one, it's not a point for clarification. Point number two, you
It's a point for cross-examination.
Yes, and Mr. Vani gave us a statement of the questions that he's going to ask. And it's under Pretoria's statement before the commission. And he gave us a reference to that statement. And it's you have the document in front of you.
Yes.
It is note number one of what Pretoria says. What he is now putting to the witness is something that was never put to the witness through her own consultations with her own legal representatives. And therefore it amounts to cross-examination. She knows nothing about what she's
Yes.
being asked about.
But, Ms. Moroka, have I not understood that there was an agreement that Ms. Fubai would be cross-examined on the basis of the agreed documents between you and Mr. Vani?
Yes, Chair, and that is, therein lies the problem. The document that Mr. Vani referred to, if I may ask you to look at what that note says, it says Pretoria's statement before,
Speak into the microphone, please.
Pretoria's statement before the Commission of Inquiry. He then gives you the page. The one that he's doing now is not before the Commission.
Yes. Mr. Vani?
Chairperson, my learned friend is mistaken. The passage is not from a statement that Mr. Pretorius made before this commission. It's in his supplementary affidavit before the Rodriguez matter.
Yes.
And the affidavit in question was put up as part of the bundle. It has in fact been part of the commission record since the beginning.
Yes. Yes. Mr. Vani, I think this issue came before there was permission for you to cross-examine Ms. Kubai. And there was an arrangement that you would follow your cross-examination that you've indicated in your cross-examination application. And the objection by Ms. Moroka is that your line of cross-examination now is outside the agreed parameters of the cross-examination that she has agreed to for Ms. Kubai. If your question were to be allowed, we'll have to adjourn these proceedings to allow Ms. Kubai to go through all the bundles that you have provided her with to enable her to be properly prepared for cross-examination.
Chairperson, I must confess, I'm at a loss as to the notion of parameters. There was never any agreement as to parameters per se. We put up documents. This is one of the documents we put up. And we even went so far as to put up 2 pages setting out the issues we wish to canvass. And this is one of the issues.
Yes.
But Chairperson, perhaps just to expedite matters, can I make a suggestion?
Yes, you may.
This is not a particularly material point. I'm happy to move on from it.
Yes, you may proceed to do so.
Let's then skip the extract from the affidavit of Mr. Pretorius before the Rodriguez Court. Minister, I want to refer you to a passage from the judgment of the Supreme Court of Appeal in the Rodriguez matter, and in dismissing Mr. Rodriguez's appeal, and I'm going to read a line from paragraph 26 of that judgment.
The relevant page.
It's at paginated page 56 of the bundle. it reads as follows. It was during this 14-year period, 2003 to 2017,
Which, my apologies, Chair, I'm lost. Which paragraph?
Yes, are you at page 56, Minister?
Yes, I am.
Yes, which starts with the period 2003 and 2017.
Okay. I'm there, Chairperson.
Yes,
Thank you.
you may proceed, Mr. Vani.
thank you, Chairperson. It reads as follows. It was during this 14-year period, 2003 to 2017, that the executive adopted a policy position, and I emphasize the following words, conceded by the state parties, that TRC cases will not be prosecuted. It is perplexing and inexplicable why such a stance was taken, both in the light of the work and report of the TRC advocating a bold prosecutions policy, the guarantee of prosecutorial independence of the NPA, its constitutional obligation to prosecute crimes in the interests of the victims and survivors of those crimes. So, Minister, the SCA in its judgment essentially said that the executive adopted a certain policy and that the parties in that litigation, which included the Ministry of Justice, which I believe was the second or third respondent, conceded that point. So essentially the question that I'd like to put to you is that we have assumed that since then the stance of the ministry has been to accept that interference did cause delays in the prosecution of the TRC cases. Is that still the stance of the ministry?
Commissioners, as I explained previously, I have no knowledge of such. If you are to come to such conclusion, you must have evidence before you. You must have received a report. You must be briefed that this is what has happened. Because if we are to run a state on the basis of what the other person has said without evidence, it's a problem. I do not know why the parties did not contest this matter in court, and I do believe that because those parties, as I said previously, my predecessors, for my gods being on my side, they're still all alive and can be brought before the commission to explain for themselves what happened under their leadership and how matters were decided, what had happened in this case. Neither does, at the time 2013 to 2017, was within the environment where I would be exposed to these matters to be able to account and explain and assist Advocate Vani for me to do that. Unfortunately, I'm not in a position to explain. I can only explain my position on the matter currently, what informs it, and how we have been able to come to that determination. Whether it's a position that is different to the previous one, I have no way of making that determination, because in my area of work in terms of how we operate and how I've been trained and taught and how I've come to understand government as it works, as a minister, you can never have an opinion of your own. You must be able to have documents that are before you, evidence, information, for you to take rational decision. Now, if I'm to sit here on the basis of this paragraph and make a determination, it will be an irrational decision because I do not have any document that submits and gives me evidence what led to the SCA to take this decision. I've not had time to go through all the papers to understand the context, because you'd have even to go and hear and look at the videos to see how the councils have argued, and I cannot make an opinion on this matter, Chairperson.
Thank you, Minister. So as I understand your evidence, at the current stage, you have not been able to make a determination from the side of the ministry.
We don't understand that question, Chair.
I don't.
Well,
I don't understand.
let me rephrase it. You've indicated that you don't know how the SCA reached its decision and conclusions. that happened before your time. You've indicated that this is a matter for the Commission to look into. So am I correct in saying that from the standpoint of the Ministry, you were keeping an open mind, you haven't made any particular determination on this matter?
Correct. And as I said, that's why, as government, we have taken a decision to establish the commission, because matters were brought forward to say there is a need, there is allegations that there's been people who have done political interference that we do not know of. And that's why the commission was established for this purpose particularly, because we do not have these answers. And we agreed, as you remember, Advocate Vani, this was as a decision from the court that we agreed together with the president. If you look at the affidavits that we confirmed, because I signed a confirmatory affidavit to confirm that I agree to the establishment of the commission, on particularly because we do not have this information before us. I sit here, I do not have, and we're looking forward to the outcome of this commission to assist us as government, both as Minister of Justice and the presidency, to be able to determine what has happened. Only then we'll be able to know what has happened, Chairperson. I can say that. Currently, as I've explained, the process, how it works, and why we would be here. And I want to reiterate again, Chair, through your permission. The Minister of Justice, in terms of her responsibility in this country, is a quite sensitive position. When President establishes a commission, Minister of Justice is not expected to have opinions in the public domain, because Minister of Justice is the advisor of the President. Recommendations on what President has to take a decision on comes from the Minister. And that's why I always say, what is of the opinion of the Minister shouldn't be known in public. What must be known is the decision by the President as an advisor. And that's good governance, and that's how confidentiality as well, and how governance system would actually ensure the effective running of government, especially in protection of the office of the President.
Thank you, Minister. That's actually quite helpful for us to know. Chairperson, no further questions.
Thank you. Mr. Siminya, is it Mr. Soni?
It's going to be me, Chair.
Yes, Mr. Soni.
Minister, there are three broad issues I want to raise with you.
I'm battling to hear.
Just a moment, Mr. Soni.
Minister, there are three broad issues I want to raise with you. Can I first take you to the report you received from Advocate Betoy?
Through you, Chair, my report or the other one?
I'll
Give us the
it is
relevant
her
page,
report.
Mr.
Yes,
Soni.
Yes, as you please, Chair. It is the report that is SA6, dated 25th of February 2025, from Mrs. Batoy to you.
Page?
The page, Mr. Soni.
Sorry, Chairperson, page 50. The report starts at
50.
50, yes. Now, if I can ask you to just keep that report in mind, and look at the issue that Ms. Batoy raises at paragraph 7.3 of her report. Now, I'll just read it very quickly for the purposes of my cross-examination. This says, in the normal course of investigation, a crime scene will be attended to by members of the South African Police Service as soon as it is discovered. A crime scene is photographed, a post-mortem examination performed on the deceased, witness statements obtained, etc. The investigation of TRC cases in most cases requires that a docket be reconstructed because the crime docket, which would have contained all the required information to inform a crime, was either destroyed, missing, or misplaced. Now that is Ms. Betoy's description of how investigations ordinarily take place. I'm just, that is her description. I'm not
Correct.
asking you to agree with it, I'm just saying that is the description. And what it says is central to the investigation is the investigator. I see you shake your head. Does that mean that's...
I'm trying to follow. I don't know whether it's a question.
Yes, it is.
Okay. I might have missed. What
Now I'm
is the
saying
question?
central to what is said at 7.3 is that it is the investigator who does those things.
Correct.
Now, can I ask you to please look at paragraph 4.1 of Ms. Betoy's report, which is at page 52. And what she says is that the approach adopted to TRC cases is, and that appears at the third line of paragraph 4.1, that this is aimed at prosecution directed, prosecution guided investigations.
Correct.
See that. And it seems that the approach adopted is that it is the prosecutor who guides the investigation in respect of TRC cases.
I wouldn't know completely, Advocate Sonia.
I'm just saying that's what it seems like here, but perhaps I could take you to another passage.
I'm very worried about making assumptions,
No, I understand.
especially under oath.
I understand perfectly, Minister. Now, take you to paragraph 5.5 on the next page, page 53. You see it says, once an investigation is registered and an investigator appointed, the matter is referred to the DPPs to appoint a prosecutor. All prosecutors must guide the investigation from the inception of the matter. I'm saying now that that makes it very clear that it is the prosecutor who guides the investigation.
Commissioners, may I say something? This area of work, these are detailed operational matters that a minister cannot get involved in. As much as the advocate is explaining, I wouldn't be interested in these areas. I'm interested in the output. Are you dealing with the prosecution? How are you dealing with them? Are you meeting the targets?
Yes, but wait for the question. It's still coming.
Oh, okay.
Now,
Because my concern was that it seems like he wants me to confirm.
Yes.
And it's
No, he
operational
wants,
matters that
he
I
wants
can't
you to
confirm.
understand what he is referring to.
Okay.
now, Minister, we know from evidence that has been led, mainly through the NPA, that TRC cases have in fact been prosecution guided, or prosecution, or the investigation of TRC cases has been prosecution guided or prosecution led. I'm just making that point to you. You are not here, but that is the evidence. Now, I want to put something to you that may well have been the position prior to certain amendments to the NPA Act in 2008 and amendments to the Police Act in 2008 and 2012. Because in 2008, the DSO was disestablished and the DPCI was created by the Police Act. I'm giving you this background and you can think about it. And it appears to us that effectively after 2008, when the DSO was established, the notion of prosecution-led investigations was outdated and it now had to be led by the police. I'm putting to you our proposition. I'm not asking you to agree with me or not.
It's not correct, though. I must put you on record.
Sorry?
It's not correct.
You say, sorry, what's not
We
correct?
have not stopped prosecution-led investigations.
Yes, right, and
It
that's
still
the point
happens even today.
and that's the point I'm making.
Okay.
And the point I'm going to ask you is, in relation to Ms. Batoy's report to you, have you come across any indication that in view of the changes that were effected to the Police Act in 2008 and in 2012, that the notion of prosecution-guided or prosecution-led investigations in respect of TRC matters is no longer consistent with the powers granted to the police and the removal of certain powers from the NPA? I'm only asking if you have come across anything to that effect.
Commissioners, if I may, and I'll make examples. NPA, and we do have cases where we do investigation led by prosecution. The current task team under Madlanga is prosecution-led investigation. The law allows, so it's not accurate to say that since 2008, with the dissolution of the DSO, NPA lost the powers of prosecution-led investigation. The NDPP, in terms of the powers, is able to do that, establish that, and do. But in addition to that, that's why there's establishment of IDEC, because those amendments as well gave NPA an opportunity to be able to do that. So you are able to do it in terms of the powers of the NDPP, and the Act allows it. The NDPP can set up a team working together with investigators, either within NPA, because we do have that investigation capacity, or can partner with DPCI to be able to do investigation-led, prosecution-led investigations. So, and just to clarify again, we do not have a specific policy that falls within area. So it can be called projects within NPA. So what they will do, the policy, overall policy of prosecution is the same. So it will apply in different times. That's why I can make reference to Section 38 policy. Section 38 policy applies across NPA. So it either you're dealing with these cases in terms of specialized commercial crime, you're either dealing with the issues that relates to TRC, you're either dealing with normal criminal matters. It depends at that time what informs the approach, and the NDPP together with DPPs can make a decision to say, on this area, this is what we'll definitely do. So my understanding of the report as I received was NPA, the NDPP saying, in terms of my work, in this area of work, this is what the approach I have taken in terms of making sure that we are able to ensure we fulfill our responsibility. Thank you.
Minister, the idea of raising this with you is to really ask whether you have come across any opinion on whether the 2008 and 2012 amendments to the DPCI has required that this method of investigation may not be consistent with it. I'm just asking that question.
I think I'm not minister responsible for DPCI. Protocol dictates that the minister responsible will be able to give opinion about the functionality of their portfolio and their entity. whether in terms of the changes that have happened, and I would be wary to give an opinion about an entity that does not fall within my ambit.
So, Minister, let me just say to you what has prompted this line of questioning. The South African Police Act, since the 2012 amendment, at section 17F, which is titled if you have it with you, that would be nice. It's at page 109 of that, Minister.
What is the section again?
17F, Commissioner.
There are no pages on this thing. They're not numbered.
I think on the
Your
top
bundles-
right-hand side
The
in
bundles
black.
are not numbered what
No.
I have as a file. Okay.
So you'll see.
I'm there. Thank you.
Okay, and you'll see that these, by the way, are the powers of the DPCI. It says, subsection 1 of 17F says, government departments or institutions shall, when required to do so, take reasonable steps to assist the directorate, and directorate here is DPCI, in the achievement of its objectives. But it is subsection 4 that I want to especially draw your attention. And that says, the National Director of Public Prosecutions must ensure that a dedicated component of prosecutions is available to assist and cooperate with members of the Directorate in conducting its investigations. And a point I want to make is, it is the prosecutors who will assist, but the investigations will be done by the investigators of the DPCI. Now, I just want to ask again, in the light of these amendments, and I have to say to you, Minister, now that you mentioned the Mandlaga Commission, it is the very issue that is the focus of attention, where the powers granted to certain sections, for example, IDEC, and IDEC in that matter has the power to investigate under certain conditions, and that's an issue there. And we just thought that maybe we need to look again at the way TRC matters, which started in 2003 with prosecution-led investigations, whether since the amendments that approach is still correct. And I just raised that with you so that at the end of the day, the Commission would make a decision on this issue. And I thought I'd give you the opportunity to comment on it because it is contained in Ms. Patoy's report to you.
Thank you, Commissioners. I think the first thing, if we look at that section 17.6, section 17F, 1 on government departments. Yes, it does provide for us to provide support. But the support, for example, if DPCI needs support from Minister of Justice, it will be the Minister of Police that writes to the Minister of Justice. So Minister of Justice doesn't jump from Department of Justice and Constitutional Development and go directly to DPCI without the Minister. So that's the correct procedure in how it's done, in terms of how support can be required. But in terms of the heads of institutions, the two heads of institution are able to partner and work together. We've got what we call net joints and joint operation. You'd remember, Chair, during COVID and other times where we have a potential heightened of criminal activities, we have what we call fusion center. That's where all the heads of institutions that are fighting crime as law enforcers sit. And in that, they are able to jointly operate, understand where the parameters of work are happening, and collaborate in that matter. But they would be able to explain in detail, because that is done at an operational level. It does not involve the ministers, and it shouldn't involve the ministers at this level.
Yes.
Chairperson, I accept. I just wanted to draw the minister's attention to the fact that, well, perhaps I should put the question. Minister, I raised this matter with you purely on the basis that in terms of section 179(6) of the Constitution, you have overall oversight of the NDPP, and although you can't interfere in operational matters, as you correctly say, it is a matter that perhaps needs to be looked at, and I'm just raising that to you and using this opportunity to do so.
It is agreed, Chair, and hence I'm making examples of cooperation. So if we look at this legislation, I can practically give examples of that cooperation that is envisaged by this Act. In terms of practical terms, I've made an example of Fusion Center, I've made an example of the task teams, and I've made an example of how we would cooperate. So where I'm sitting, there's no lacuna, and there's no confusion in terms of mandates, and there's no conflation in terms of responsibilities. Because if each and everyone follow their act, would know this is my lane, this is where I need to deal. What we should not do is amend laws, change policies because of an individual that has acted inappropriately.
I've made my point to you about the possible inconsistency of the approach with the amendments that were introduced in 2012. Minister, I want to move on to a separate issue. My learned friend, Mr. Varney, referred you to the Rodriguez case, and he referred you to a matter in the SCA. I want to ask you to look at the bundle that was earlier given to you, where the SCA judgment is, and to refer you to the full court judgment in that matter. And I want you to look at paragraph 65 on page 26 of that judgment.
Page?
65.
Sorry, page 26, paragraph 65. Now, Minister, before I read to you...
Page?
Page 26, paragraph 65, Chairperson. Now, Minister, before I deal with the passage that I want to refer you to, may I just point out that based on the evidence before the full court which decided the matter, and my learned friend has already told you what the matter was about, Mr. Rodriguez asking for a permanent stay of prosecution. What the evidence before the court was that there was political interference, and that those allegations were made by the NPA itself, as Mr. Varney. I don't want you to comment on that, and I accept the point that you would need to look at. But having accepted that those allegations are correct, this is what the court said at paragraph 65 regarding the alleged interference, and I'm putting it no higher than that. It says, for these reasons, the conduct of the relevant officials and others outside of the NPA at the time should be brought to the attention of the National Director of Public Prosecutions for her consideration, and in particular to consider whether any action in terms of Section 41(1) of the NPA Act is warranted. Now that's for the NDPP to do. It's the second paragraph, it's the second part of that paragraph that I want to bring to your attention. It says, finally, there must be a public assurance from both the executive and the NPA that the kind of political interference that occurred in TRC matters will never occur again. In this regard, they should indicate the measures, including checks and balances, which will be put in place to prevent a recurrence of these unacceptable breaches of the Constitution. Minister, I accept you were not there at that time. May I ask you, though, do you know if the measures and the checks of balances that the full court said should be instituted to ensure that this never happens again? Do you know if there are such checks and balances?
Commissioners, can I start first? Advocate Sonny says, having accepted that the comments are correct. I don't remember accepting that. I do not accept that
No,
the comments
it's not
are
you,
correct.
the court.
Or not me.
The
Okay.
court.
Because he made it as if it's
Yes,
me.
it's
So I
the
want
court.
it to be on record. I thought I heard him saying, I have accepted.
No, no, no.
Okay,
I didn't,
thank you. Thank you for that. I'm comforted. Advocate Sonny, the issue for me here, as I said at the beginning, when Advocate Moroka was leading me through the evidence, is that I've not dealt with this matter. I had not knowledge until we had to compile these documents and started working on the processes. That's the first issue. Second issue of it is that the minister that is responsible for this is still here and would have to give assurances. What I can account for is my tenure, what I have done, which I do believe that I've given the assurances to this commission of the work. Firstly, arriving in the portfolio, asking for the report, looking at the areas where there are gaps, closing those gaps, ensuring that the work happens, assuring NPA of its work independently without interference, and I can assure you, Chair, you can call all of them here. They will attest. I've never interfered and have no intention of ever interfering with the work of the NPA to do their work. What I provide is support, and I can assure you that in terms of my work, we found that the alleged individuals did not agree to come to court because they were not provided with legal support. And that was delaying the processes. I then agreed to amend legal aid, South Africa's policy, so that we can allow the individuals to be supported to go to court in terms of our constitution. Number two, their families were not supported to go and hear the matters. I have ensured that they are supported to go. All those applications that have arrived on my desk, I can assure you, commissioners, within 48 hours, they were signed off. If you look at the record of their arrival in my office and the record of signature and out of my office, is less than 48 hours. So in terms of efficiency, I have ensured that there is, I can account for my work, I can account for the work that I needed to do, but not only in terms of prosecution, but in terms of the implementation of the entire TRC report, including ensuring that the turnaround time of the housing reparation is done in time. When I found that the people who needed to get their once-off reparations have not, and there are 4,000 that have been sitting for years without, we went as far as saying, let's advertise in the newspapers so that that can be. That's the assurance I give to this commission, an account of my work and my involvement under my leadership, both in terms of the department and NPA on the work of the TRC. Further than that, unfortunately, I will not be able to assist.
Minister, even a yes or no could assist. Have you come across whether these checks and balances that the court speaks about have been effected? Do you know? Don't you know?
Chairperson, yes or no, it will be difficult because you've got to know which checks and balances needs to be in place.
That the court is speaking about here.
As I alluded, Chair,
What was read to you?
as I alluded that this was not brought to my attention, the context, I'll have to go back and understand the context. I got the summaries of the documents. And that's why, for me, I'm accounting to say when I was briefed, including NPA, never raised the issue of interference with me at all.
Yes. Minister, I think as I understand your evidence is that, in short, you are not aware of any measures that were put in place in this regard, since it was before your time. Am I
Correct, Chair.
correct?
Correct, Chair.
Minister, just to conclude that, and I don't want to take it further than it is, but just to conclude that it's now been brought to your attention that the executive and the NDPP are required to put in place measures. It's now been brought to your attention. I take it you will attend to it.
Chair, Commissioners, currently,
If
I
I
do
may,
believe
Chair.
that measures are in place. As I explained, that I receive regular reports in terms of progress of what needs to be done, in terms of the TRC inquiries. I have provided evidence to the Commission since my arrival of what I have signed. In terms of the work that needs to be done, currently is being done. In terms of allowing NPA to be independent without interference, as the Minister, I assure this Commission, there's not been independence. There's not been any interference with NPA.
Minister, may I then get to the third and thankfully the last issue I want, last set of issues I want to raise with you. One of the matters you have raised is the independence of the NDPP, and it's something you respect. And I see you're nodding.
Correct, Chair.
Yes. Now, one of the mechanisms to ensure that there is not only independence on paper, but actual independence is to ensure that the tenure of the person appointed is secure. So, for example, Section 12 of the NPA Act provides that the NPA shall be appointed for a period of 10 years or until he or she reaches the age of 65.
I
You
remember
accept
it.
that?
I don't have to go to it. but
It's Section 12, and I'm just
Okay.
telling you what it says. Now, I just want to, in the light of that requirement and in the light of the fact of independence being tied to security of tenure, similarly with judges, I just want to point out the following to you and ask your comment on it. The first NDPP appointed under the NPA Act, the existing NPA Act, was Mr. Mr. Bulelani Nguka, and he was appointed in 1998, and he left the position of NDPP in 2004. So he served for 6 years. The next NDPP was Advocate Piccoli, who served from 2005 to 2007. It's a period of about 2 years. The next NDPP, who was in an acting position throughout his tenure, was Advocate Mshe, who occupied the position from 2007 to 2009. Then Advocate Similani was appointed in 2009, and he was removed by virtue of a constitutional court order from that position in 2012. Then Advocate Nkosana occupied the position of NDPP for a period of 2 years from 2013 to 2015. Then Advocate Abrahams occupied the position from 2015 to 2018, a period of 3 years. And Advocate Batoy occupied the position from 2019 to 2026. As I understand it, she didn't serve the full 10 years because she had reached retirement age. And now, of course, we have Advocate Matubi, who's just been appointed. Now, it seems, well, the only person from 1998 who served a full term of office was Advocate Batoy. I just want to ask, Minister, how does this, or is this not likely to affect the efficacy of the entire NPA when the period of office is expected to be 10 years and it is in the period of generally about 3 years?
If I may bring to the attention of the commissioners, on terms of the NPA Act, page 10, where it's NPA Act section 12, 2B, where it gives indication in terms of the removal of a national director and deputies in office. Actually, when you go from 5, in terms of when can you remove a national director in office in terms of misconduct, account of continued ill health, account of incapacity, account thereof in terms of fitness to hold office. The reason why I'm taking the commission from that page 10 to 11 is precisely to explain the check and balances that are there. It is not easy, Chair, to remove a national director of public prosecution. You'll have to hold a fitness of office to hold office, and therefore that is done with a chairperson being a retired judge. Now, in the manner that Advocate Soni is bringing, it seems that the insinuation, and I could be wrong, the insinuation is that the security of tenure is not guaranteed. I do believe that this is guaranteed. No office in this country takes such a measure in terms of removal of a person in office, including that of the president. If we look at even the cost of it, I joked the other day, I said, to remove a prosecutor from office, actually it could cost you more than 20 million. Now, with the checks and balances in terms of the Constitution and what this Act provides, I do believe that that assures the nation, in terms of the person that holds that office, that they have security of tenure in the manner that it is provided for them to have a space to take decisions without fear or favor. Because it will not be a minister, nor the president that wakes up tomorrow and saying, I'm firing you. It will have to be an inquiry that is public, that tests whether the allegations are malicious or are correct. So I do believe that these clauses, Chairperson, are one of those that we must support as they ensure the independence of the NPA.
Minister, I'm making a slightly different point. I'm not suggesting that it's done maliciously. I'm just pointing out in terms of the effect for an important law enforcement agency when you have, during the period from 1998 to today, when you have 8 NDPPs, it is unlikely to result in an institution that would be properly serving its full purpose for the country. That's the only point I'm making.
Could one even add that is it a good thing to have several acting NDPPs? I think Advocate Jiba was omitted from from the number. So in your response, you could factor in what I've now also put to you
May
in
I
connection with
factor-
acting NDPPs.
My factor, Chair, because that would be unfair. Advocate Jiba had an inquiry chaired by a retired, now late, member of the Constitutional Court, and she was declared not fit to hold office. So sorry.
You're missing the point. She was acting. She was never substantive, Ms. Moroka. I'm talking about acting. Could you then respond, Minister?
I might have missed the question. I'm not so sure what I'm asked to respond to.
Yes, Mr. Sonny?
As you please, Chairperson. Minister, the only point I'm making is the Constitution requires a person who will act without fear, favor, or prejudice.
Correct.
The Act provides that in order, and it requires independence. The Act provides, and I'm saying one of the reasons for the 10-year, not the only reason, for the 10-year tenure of appointment is so that the person can act independently and not be worried that if I do something that the executive might, or the president may be unhappy with, I could be removed. So I'm just saying that what is envisaged totally is a period of office of some duration. Doesn't necessarily need to be 10. You can't have, well, it's not envisaged that it will be periods of office of just 2 to 3 years. And is that not a matter?
The
that
proposal to reduce, I'm battling to hear you.
Oh,
Is it the proposal to reduce the years
no,
from
no,
10
no,
years?
no, no. I'm saying the fact that persons serve for such short duration can't be good for the NDPP.
I'm lost. Person who are short, meaning as acting, they are not good for NDPP.
No. Minister, let me start again. And it's not a criticism of you. I'm just...
No,
just
I
wa-
don't take it that way. But I'm trying to understand so that I
Yes,
can
no, I
help the
understand.
Commission.
So the Act envisages that when a person is appointed as NDPP, the person will be appointed for a period of 10 years, and it is expected that the person, unless the person is removed from office, will serve the full 10 years.
Correct.
And that's to ensure continuity in the fight against crime.
Correct.
You accept that?
Yes.
Now, I'm saying that if you look at how the short duration for which the NDPPs who've been appointed after Mr. Nguka served until Ms. Batoy, that is inconsistent with what was envisaged. And I'm just bringing that to your attention so that one can say, well, to the extent that the NDPP may not have been performing, that's a factor to take into account. Would you accept that?
Maybe let me I hope I understand it correctly, Advocate Sonia. The issue of security of tenure can be informed by different issues, especially when you look at the durations. When you appoint, I sit and appoint quite regularly, and even in various capacities, whether you're appointing judges, you're appointing magistrates, you can never determine that I'm appointing for a person to leave, commissioners. You appoint in the belief that this person is going to fulfill their responsibilities and they are going to do their work. And when that does not happen, you can't say because I want them to finish 10 years and therefore I'm not going to act, because the Act does require that when something goes wrong, there's been quite a number of fitness to hold office that have been there, quite a number of all these processes, including some of them ending up in court, where there's been court challenges of particular appointments by the president on particular NDPPs. And one of the issues that President Ramaphosa looked at, for example, was that perhaps there is a need for us to look at how we appoint. And as a test, then a panel was put together when Advocate Batoyi was appointed. It was public, it was transparent, and therefore the appointment. We would have tried to do the same when Advocate Batoyi was going on retirement, to try and find and open it in the process. So those are things that will continue to upgrade, will continue to review in terms of legislation where the requirements is. Currently, we are actually looking at the security of tenure, particularly in terms of not only the NDPP or that, but what comes across now in terms of security of tenure of the whole appointment of the president's people who are appointed in terms of the act by the president, in terms of the, because you have an NDPP that has 10 years, but the deputies are lifetime until they retire. So that is an inconsistency that we have found, that we are looking at. In terms of the NDPP, we do believe that the current provision does give us a leeway. There are those who are proposing that maybe you must extend it to 70 years like you do with the judges. Others are saying no, 65 is correct. And when we do, because we are currently in the process of reviewing the legislation, when we go out in public, we look at what the public is recommending and for us to be able to deal with the issues. Mainly currently the work that we are doing is the operational and financial independence of NPA, so that NPA can have its own accounting officer, so that the accounting officer does not become the DG of the Department of Justice, but the accounting officer will be a person that is in NPA. But in terms of the proposal as well, looking at the constitutional imperative, the minister will remain, because that's the constitutional responsibility of ensuring access to justice as well. But similarly, we do not want to involve the NDPP in the operation, because the NDPP must not be tainted by issues. For example, tomorrow you have NDPP having to appear before court for corruption because the tender didn't go right. So those check and balances must still be in place to protect the office of the NDPP. I hope I'm assisting Advocate Vani to my best ability and to the Commission. Sonny, sorry, I said Advocate Vani, Advocate Sonny.
Minister, let me assure you that I perhaps should have pointed out that since the appointment of...
Mr. Soni, maybe you could wait a bit, but you wouldn't let
There's
this
some
point
background
go.
noise.
You wouldn't let this point go because
No, I won't.
it seems we're not going to get anywhere, and you might wish to address it at a later stage.
Yes,
I don't know. I'm not stopping.
No.
I think you have been answered, Mr. Soni,
Yes.
in so many words, that it is
as
an
you please.
issue that has come to the attention of those who are charged with it, and they're addressing it.
As you please, Chairperson. Chairperson, we don't have any more questions.
Minister, just a short point, and you must excuse my ignorance when I say your report concerning reparations is the most comprehensive that I have come across. If I can then just zoom in on one aspect that it seems most witnesses would not commit, maybe for good reason. If we go to the terms of reference, because we must deal with what the President has proclaimed, paragraph 1 thereof says, the Commission must, in relation to the period since 2003, inquire into, make findings, report on, and make recommendations concerning the following, guided by the Constitution, relevant to legislation, policies, and guidelines. And I go to 1.4, whether in terms of the law and fairness, the payment of any amount in constitutional damages to any person is appropriate. If anyone can comment, you can.
Was that an aish?
It is, Commissioner, it's very difficult for me to comment on that in light of my role.
As the advisor to the president,
Yes. I am finding it difficult to answer that question. I don't know if I'll be in trouble.
have I answered myself?
My issue is, let me explain so that I don't want to get into trouble, having not cooperated. My difficulty is that that's one of the areas that we are requesting guidance from the Commission. Now, if I can have an opinion now, when the report comes, public can say, will she implement it because she's already had an opinion? And that's what I'm running away from. Because once you make a recommendation, the president will be sending that to me as Minister of Justice to implement, Commissioner. And that's why my difficulty of saying the opinion, I don't know if I get into trouble for that. Because I don't want the public tomorrow to say, we don't trust her because she had an opinion. Let's say my opinion says there shouldn't be. Then if the commission says, yes, go ahead, how will the public trust me to enforce that when I had an opinion? It will create doubts in the public domain about my commitment to implementing. And if tomorrow there are difficulties, people will not trust the difficulties, to be honest. They will say she's putting the barriers because she never in the first place believed in this thing.
Yes. No. Thank you. Maybe you are justified to run for the mountains, Mr.
Thank you. I'm indebted to you.